Hello, everybody, and welcome to week 4. Um, and this is our legal week. This is where we take a little bit. If you've had business law, some of this might be a little bit of a review. For those who haven't had business law, this is going to be all new material for you. We're going to talk about contracts, risk management, and all those insurance things in between. So what we're going to do is take a look first at, this is obviously the first run is contracts. Okay. So we're going to assume that you do not know anything about contracts, and go ahead and kind of go through just a little bit of an understanding of what contracts are. Contracts are formalized, used to formalize business relationships. Okay, so it's an agreement between two parties. So when you take a look at those, also it tells you what happens if one or the other parties doesn't fulfill their obligations under the contract. Okay, it also assigns the delegation of duties, who's responsible for what, and we really kind of need to understand how contracts work as managers. Because we use different kinds of contracts. You're going to have an event contract. You're going to have a food and beverage contract. All of those are all signed and legal documents that are binding that we have to agree that we have to carry out. So when you take a look at a contract, we're looking at two different things here. We've got an offer, which is a promise of some kind, or a refrain from doing something. And it's basically there's typically you're going to have parties involved. You're going to have the subject matter of it. You're going to have the time and place for what the performance is. You're going to have all the consideration aspect of it. So all those aspects that are set with any particular event, it's all going to be lined out in the contract. Also, you have acceptance, okay, which means both parties now agree with that. And there's also implied acceptance when an acceptance by silence. You don't see those in our industry too much. Typically what you're seeing now is you're going to see much more of things along the lines of typically it's going to be expressed acts. It's going to be something that we're going to you're not going to usually imply acceptance or acceptance by silence in our business. And in order to get there, you're going to have some negotiations, some back and forth between the parties. So you take a look at this consideration, okay? So there's an exchange of value between between the parties. So in other words, if it's a concert, I'm going to put on this concert in exchange for a set amount of money. Okay. If it's an event contract, then it's going to be one of those where it's going to be, I'm going to put on this event, and I'm going to agree to all these things, and this is what I expect on the other side. It doesn't have to be equal, but typically, and a lot of times these contracts aren't equal. They may be in the favor of one side or the other. Capacity, okay, the ability of a person to or the power to enter in the agreement or the contract. So what you need to do is when you have that capacity is you have to be able to have the power or the ability to enter into a contract. Certain types of individuals can't enter into contracts. People who don't have a party, don't have a say in the matter, or you have an inability to make a contract for one reason or another. There has to be intent as well, which means you have to intend to agree with this. There's also the aspect of specificity. So in other words, as most lawyers agree, okay, and I'm not a lawyer, but as most lawyers are, they want to make everything as precise as possible. Leave no stone unturned. Okay, so now we'll take a look at these aspects of breach. Okay, so a breach is one of those where there's a difference where one party or the other doesn't fulfill their obligations. Okay, that's really what it is. So that means you've broken the contract. Okay, either through failure to perform, or you broke a promise, which is what repudiation is. You broke a promise on the contract, and or you have an interference from some other party. So those are three ways that a contract can be broken. Excuse me for a second there. And once a contract is broken, then some way or another, they have the other party who has been damaged or has been hurt by that needs to have some kind of remedy. Okay, compensatory damages, which is basically is it what happens if they break the contract. Okay, liquidated damages. Which is on the liquidated damages is what if you have to liquidate something, which is basically get rid of something. So if you were purchasing something, for instance, and the contract didn't go through for one reason or another, then those would be liquidated damages. They would actually you would be entitled to being sold there. You also have specific performance. So if the performance doesn't go through, they can be rescheduled, and then it can be reworked. The contract can be reworked that way. That happens a lot in concerts. If the performer can't go on for one reason or another, they usually reschedule, or they make arrangements to refund everybody. And then for breaking that contract with the facility, there's actually some specific aspects in there that where you have to pay for some costs depending on how close to there is and what other costs are there. Defenses, if you break a contract, there is a couple of things that you can do. Impossibility of performance. In other words, there's no way you could carry through with that. Frustration of purpose. Or a frustration at purpose. So if there was the purpose of the contract, and then somebody decided that the purpose changes or something along those lines, then that's a defense for breaking the contract. You don't see that too often, but that does happen occasionally. And contractual impracticability. So if something happens that you can't perform the agreement there, such as weather, that makes the contract actually become impractically to enforce. So if you have to call a concert off due to an outside venue that has all of a sudden it's lightning and you can't perform the concert, then that means that the contract is not practical to be enforced in our business. These two types of contracts are basically, it's pretty easy. One, unilateral means one party promises to perform something. The other party is not bound to accept or perform. If the acceptance occurs, the first party must follow through on the promise. Okay, so basically, it basically means it's a one-sided contract. So somebody basically says, okay, we can perform that act. Bilateral means that there's a contract, basically an agreement between two different people or two different parties, and there's promises on both sides, and each one is conditional upon the other's performance. So in order to make sure that the contract is executed. Okay. Now, everybody makes mistakes. This happens all the time. Misrepresentation. Okay. Misrepresentation is basically facts intentionally or unintentionally, basically misconstrued. So if something happens in the contract, and it doesn't have to be intentional, it can be just unintentional. That could be construed as misrepresentation. Okay. Undue influence or duress. Okay. Where there is disparate power positions of the parties. So in other words, if somebody's holding you over a barrel, as the saying goes, so that means one person has extreme power over the other. You can kind of see this where we talk about in the areas of sexual harassment and those things. We talk about supervisor and employee relations. That means the supervisors have power over employees, which means they could be forced to do things under influence or undue influence or duress. In regular contracting situations, it can be that one is forcing you into somebody's forcing you into a contract to do something because that's what they wanted to do. Or what they hold, somebody has power over another person, okay, or another party. I've kind of seen that happen when in the NFL. The NFL likes to strong arm facilities into entering into contracts and that are favoring them. Mistakes are opera. Yeah, typically those are just typically sometimes it's a mutual mistake, sometimes it's an unconscionable mistake, which means you can't believe that it was a mistake. But typically it's just an honest mistake. And typically a lot of times it's just an honest mistake. And courts don't usually protect parties from making mistakes. So basically if you make a mistake, the courts are not going to really allow you to sue. The integration clause means that contract is as is. So the parole evidence rule is one of those where parole evidence means that you've got to actually have evidence that there was actually a part where everything. When you talk about integration, means that it's intertwined. Okay, so we're basically in the contract as is. Okay, so whatever's written on the contract, it is what it is. So if something were to happen on that, an error on that, you would have to have some kind of major evidence to prove that that there was intent on the other party. So to carry and this is a tough thing to prove because contracts typically are as written. Okay, so for you to prove that there was intent, it's very difficult to do, especially if it's an error. So these are some contracts that I kind of alluded to in the beginning that you're going to see in the sports and entertainment world. What you've got is independent contractor agreements. There's a lot of those. We used a lot of those from independent contractors for things like beer vendors, soda vendors, what we call the stand hawkers. So that people walking up and down the stairs offering you with tubs of soda and product that they sell. That's typically an independent contractor that's doing that. We used independent contractors also for certain specialty products. For instance, when we were at the arena and the stadium, I used a vendor that used the sugared nuts. He was an independent contractor that we entered into an agreement with. So those are what those types of agreements are. And a lot of those we didn't use them a lot in the employee perspective because typically independent contractors they're difficult to handle from an IRS perspective. So and typically if you use them, you get if they do specify, do we withhold taxes, do we not hold with taxes? Typically we don't. That's up to the contractor to pay. And who provides the tools and those types of things to do the work. So in the vendor's case, like the hawker's case, typically we would provide the tubs and the materials for them to use, and then we would inventory out, inventory in. All those things would be specified in the contract with them that they were responsible for. Facility contracts, we kind of talked a little bit about those. That's a contract to rent the facility out. And then game and event contracts, these are typically single or use series of games or events. For instance, a lot of times we would use an entire season's contract for the building for like a hockey league, for basketball for one of the we had basketball for one of the local universities there. All those would be specified out in a series of events because typically they're the same. Um, Unlike a concert, which is a one-time shot. Um, so sports facility contracts, as we look at these, sponsorship contracts, they identify, and as you will see in the case that we're doing, you'll see that sponsorship agreements become very, very encumbered and very detailed. Okay, you need to have all of these ideas, these aspects covered. Okay, identify the terms unique to the agreement. In other words, so what is the sponsor getting for this? Clear and detailed descriptions of all relevant ancillary elements. Like, okay, where does signage go? Where does it go in relation to other signs in the building? Where would they, you specify all of that in the sponsorship contract. Clarification of any liability issues of either party. Okay. If there's insurance involved or any of those types of things. Can be a non-compete clause in there. Okay. And you'll kind of see that kind of bridged a little bit in our assignment this week with the case. You'll see some of these where this aspect, if there's not a non-compete in there, you'll see you'll see what happens there. And the future rights, if they have any first right of refusal. Licensing agreements typically are a little bit different. Licensing agreements means that you're allowing them to use the property rights. Okay. Typically the scope of the license, like for instance, NCAA teams, they spell out where and how far that contract extends to. Specification of merchandise, management, control, accountability, who gets licensing fees, royalties, maintenance charges, any of those types of things are all spelled out in a licensing agreement. So but your license agreements only apply to property, corporate property. Okay, so now we're going to take a look at risk management. So risk management. Okay, so basically, it's our job as managers of facilities to basically manage our risk. Okay, and that is either physical or financial. Okay, our job is to minimize that risk. Okay, and that is kind of what we do. We manage those aspects of it. So we want to make sure that we manage all these aspects of things like safety, theft, all those types of things that you would think that could cause harm. Okay, and things like slips and falls. Okay, those are all things that have to be taken seriously, and literally you can't brush that off. Especially managing a large facility. We are in a very litigious society, which means we are in a society that really breeds on people suing other people. So you can lawsuit. There's lawsuits all the time, and stadiums, arenas, event facilities all have people look at that as deep pockets. Okay. It also could extend into the aspect of brand tarnishment. Okay. In other words, if you're at a football game, they look at that as being, it's a double whammy. Okay. Because you got the facility and then you've got the team. So they both could have some financial risk involved. And then comprehensive risk management plan. And basically that's one of those things where you're thinking about all these risks and figuring out how you're going to manage them. Okay, so now, sorry for that, flipping through there. So now when we take a look at this, so we take a look at what we call the risk management process, or the DIM process. Okay. So what we do is we're developing a risk management plan. Okay. So when you develop a risk management plan, you're starting to, you sit down and you kind of think about everything that's at risk. Um, you identify those risks. Then you classify those risks, high, medium, or low. And then you also classify them by the severity level. Okay, catastrophic, critical, moderate, or low. Okay. There's a table in the risk category matrices in the book under 10-1. And that risk management table basically says you list it out, and then you're going both by the frequency and then by the category. Okay. So that's how you classify them. Frequency would mean that they happen, that they could happen often, never, and then the severity. Okay, so frequency is like, slips and falls, they happen frequent. A medium one might be something along the lines of typically kitchen accidents, burns, knife cuts, those types of things in my land of the world. Back injuries, for instance, in the warehouse operations or in maintenance operations. Those are typically probably a medium frequency item, or seldom, and seldom would be things like weather, or a lightning strike, or striking a patron. Those are all types of things that would be, they don't happen hardly at all. So that would be a seldom. And severity, catastrophic is you can't. Catastrophic means you're not recovering from that. Okay, you're out there. Hurricane blows through. Okay, that's a catastrophic event. Okay, doesn't happen very often, but it is a catastrophic event when it does. When you have a tornado. Okay. Critical events typically are those things that bomb threats. That's a critical event. It's active shooters. Those are critical events. Again, don't happen very often, but they don't usually have a lot of instances where they're not catastrophic because it's not total destruction of property. And then moderate and low, obviously, are different kinds of risks. So what we do is we treat risk accordingly. Okay, and these are the four areas. Excuse me. These are the four areas we look at when you look at risk management. Okay, what you can do. You can avoid it. Okay, if you can. Things like wearing back braces at work to prevent back injuries, controlling slips and falls, roping off the area when you mop and clean and those types of things. All those types of things are avoidance, getting water up as quickly as you can, so nobody slips on it. That's avoidance. Okay. Retention means that you're going to hold on to that risk. Okay. Examples of holding on to a risk would be self-insured people where, for instance, I've known a couple of companies I worked for where they self-insure the first, $5,000 of health claims. Okay. So that's retaining the risk for them. Okay. And they're going to handle that aspect. Reduction of risk is what you're going to do is do everything you can to reduce that risk from happening in the first place. And you can reduce your risk by a good action plan. Things like what to do in an active shooter drill. At the extreme side of that, you're reducing your risk by training everybody to do what to do in those cases. You're reducing your risk of handling it when you have a water issue. You immediately there's a bunch of steps that you can do to actually reduce that risk of somebody getting hurt. The last one is you're going to transfer that risk, and that's called insurance. Just like your car insurance, okay, you're transferring that liability issue if something were to happen from you to the insurance company. And you're paying for that, obviously. And that's exactly what happens with us. Okay. So types of transfers. Okay. I just mentioned insurance. Okay. So you're basically moving those aspects out in insurance. You're transferring that risk to an outside party. Okay. Waivers means that one party is going to give up their rights to do that. Waivers, for instance, a lot of times you'll see if you're about to bungee jump up a bridge, typically they're going to ask you for a waiver because you're doing that knowing what you're going to actually do. Typically, you give up your right to sue or anything like that because you're engaging in an act that you know what you're getting into. So that aspect of negligence doesn't apply. Now, basically, gross negligence or reckless misconduct on the party who handed you the waiver to begin with, you're typically, then that becomes an issue that you could sue for. And then you got to really check with each state because each one differs on what the waiver requirements are and in order to be enforceable. Or the hold harmless clause. Okay. Typically in lease agreements, this is where you see this. You can't hold the landlord responsible for anything that happens while you're leasing the property from them. Okay. Implementing a risk management plan. You've got the actual, you have, basically you communicate that all the way through the facility. So everybody knows, that every level of the team understands, and the organization understands what the plan is, and that you're trained to handle what happens when those things happen. Okay. And then typically a lot of times you have a risk manager or a safety committee that also handles, they come into play and depending on the incident or the significance of it, then they would come into play and actually handle a lot of those issues. Or the safety committee would actually handle issues before they happen. They walk around typically and do audits and ensure that things are properly assigned in their places. Okay, now we're looking at liability and negligence. Okay, liability is typically it's the responsibility we have to our patrons. Okay, so if something were to happen, we would obviously be liable. So basically, if our patrons are people using the venue, so we have the responsibility of providing a safe environment for them. Okay, so we want to make sure that things are actually handled properly. And basically, if something happens, then we could be liable for damages. Okay. Typically, anytime there's an incident, we need to make sure that we have basically that there could be a lawyer involved anytime that we have an incident. Anything from a simple slip and fall to somebody falling off a building. Okay. So typically you've got to make sure that that we are aware that basically a lawyer could become involved and we could be sued. So when incidents happen, you'll find that there's policies and procedures involved. Document. You document witnesses. You document. You take as many photos of the scene as you possibly can. Okay, and making sure that everything is in order, because probably you're going to see a lawyer. Okay, negligence is basically the conduct basically falls below the standard established by law to basically protect somebody. Okay, it is a civil case. Okay, which means it's not criminal. Typically, it's civil. And an action or inaction of a provider caused an injury. Okay. And typically, basically, there doesn't have to be an intent there. Okay. So basically, when you look at negligence, it just means that you can't say that you intended to harm them, but something did happen. A pipe burst and there's all sorts of water there, and then somebody slips and falls and ends up with a neck injury. Okay. You didn't intend that to happen. There was no intent to harm. Okay. But they did get hurt. So then you end up with an issue where that conduct and it wasn't intentional, but it did actually happen. So we're on the hook for that. So we have a duty to protect our customers from unreasonable risk and harm. Okay. There has to be a relationship in order for this to happen. Okay. So there's a duty. Okay. So we have to have that sense of duty that if they're a customer or a client or something like that. So that duty is, we have a duty to protect them from harm in our facilities. We also have to have a relationship with them. Okay. So in other words, there has to be some kind of relationship with the facility. So, there's not negligence on our part, per se, if somebody comes in and decides to shoot somebody or they get into a fight. Okay. We're not necessarily responsible for the injuries as a facility unless they can prove that we had a relationship between those two and then also that we had a duty that we owed to them. So in other words, if a standard of care and we've got all the security in place and they end up somebody falls off and breaks somebody else's nose because they're two drunk guys. Our standard of care means that as long as we should respond quickly, as long as we know it, we respond appropriately, then we don't have we've exercised a standard of care. So that's not an issue. Then it becomes not a negligence issue. Status of us and where our is and how we fit into the picture. So those first four things are things that we have to provide in order for them they have to be present in order to prove negligence. Okay. And then general categories of patrons, typically the invitee, that's the ticket holder, the licensee. Okay. So we have licensees that are holding a license that are there. We also have duty to protect, unfortunately, trespassers. Okay. And the recreational user. Okay. Which may not be an invitee, but could be somebody else who's connected with the event itself. They would be classified kind of a recreational user. For instance, the band comes with typically a road crew, and that road crew could be classified in that recreational user category because they're not really affiliated with the stadium or the facility, and therefore we still have an obligation to protect them because they're technically in that category because they're not really a licensee, they're not an invitee. Okay. And they're obviously not trespassing. So typically they fall into that category of recreational user, which is that everything else category. Okay. So standards of care, when we talked a little bit about that, there's the aspect of reasonable and prudent. Okay. Which means basically what would happen, what would anybody else in this industry do? So it sets a standard. So once we've met that standard, then we're fine. Okay. So that aspect of being reasonable and prudent, that's exactly what we would want to do. So as long as we're handling that, typically we can minimize the aspect of negligence. And then inherent risks. Okay. There are inherent risks typically in operations. Okay. So for instance, if you're bungee jumping, you're hosting a bungee jumping off a bridge or off a mountain, there's inherent risk in there. Just like allowing somebody to free climb a mountain, there's inherent risks in that as well. Okay, you're accepting those risks when you practice those types of things. So in our operations, for instance, there is the chance of inherent risks of weather in an outside event. Okay, we can manage some of that, but those risks are inherent. If you're for instance, if you're at NASCAR and the car hits the wall, okay, there are inherent risks to sitting down close near the wall or anywhere in the stadium, really, unless you're in the uppers. But there is some risk there because obviously that is a dangerous sport. Okay, now we've done some mitigations, just like the issues with baseball and foul balls, and extending the netting around to protect those patrons, because that's become now an industry standard for care. Okay, breach of duty. Okay, the act or commission that falls below the standard of care. Okay, and you have a fail, and you've actually had a failure to act. So even though you would have to, not only if the commission happens, okay, but then you also have to failure to act. You have to actually have both of those to break the contract. Okay. So even though an act may have fallen below the standard of care, but if you took action to work on to prevent that, then that's not a breach of contract. The proximate cause, and the causal link between the breach of duty and the injury that occurred. So there can't be any mitigating factors. Okay. But it doesn't have to be the sole cause, but there could be substantial factors among others that can cause injury. So there has to be a link between the act and the injury that occurred. So a slip and fall, and then they injure their neck. That's actually that's an actual aspect of a negligent act. Okay, if you did not work to prevent that. Okay, damages. You're entitled to economic loss, pain and suffering, which is basically the agony of actually having that, emotional distress, and physical impairment. So all of those are types of damages that can happen. There's also compensation returned to the plaintiff to be made whole again. So what happens after the incident? So these are ways that you would actually get paid, or somebody would get paid. Okay. Typically defenses for negligence or to negligence would be statute of limitations, which means basically the time has run out. You can't come back, 10 years later and say, I hurt myself over there due to a fall. You've got to there's a statute of limitations involved there. You got to have the elements of the negligence claim not being met. There's an assumption of risk that's got to occur. That could, so in other words, primary assumption of risk, it could end up, for instance, that slip and fall may end up going to the insurance company. There could be other groups that have comparative or contributory negligence. So, somebody could have been horsing around and pushed that person that contributed to their fall, in my example. Or comparative negligence would be something where that slip and fall was actually was occurred because there was ice leaking from a cart on an independent contractor from down below, and then you end up with a comparative negligence there, whose responsibility for that, and immunity. There are some places where there's recreational use statutes that pertain to public buildings. So if you're in the building, you can't sue them, or you can't sue the city or the government agency that's involved in that. You'll see that sometimes in the fine print on your tickets. The volunteer immunity statutes, which means that if you're volunteering, that you can't sue in a lot of cases. You don't see this as often anymore, but you can see them. Typically, if you're volunteering for a group, typically then at that point, I know we required our own groups to have their own insurance. So before they would actually do it. And if you're trying to help somebody, that's the Good Samaritan. So if you're trying to help somebody and you end up causing them more harm, you didn't intend that, under the Good Samaritan law, typically that protects you. That's those things like using an AED, a defibrillator, or doing CPR on somebody. Your intention was not to do them harm, and you would not typically you'd have immunity from that. Okay, so waiver. When you take a look at the waiver, typically you'll find that typically it depends on the type of contract, what kind of waivers there would be there. And there could be an exculpatory clause, which means that they could exclude certain kinds of waivers or participants. So that would could become an issue. State laws also relating to waivers, typically parents of minors and public policy standards typically may also affect whether or not you can waiver something or waiver that risk. And then agreements to participate. So typically things like, run events, there's a risk involved in there. Those are inherent. And typically are not, these typically are agreements to participate. So you're participating in the mud, like a mud run. Okay, there's inherent risks in that. So there's typically not a contract, and it doesn't contain exculpatory clause or an exclusion clause. But it would basically say that you agreed to participate, and if you get hurt, it's your own tough luck. You had a choice. So responsible for liability, employee liability, we have that aspect of employees. We're responsible for employees, so they are direct contact with the people that are there. So an employee that fails to act would definitely have an issue, but that doesn't alleviate you as the supervisor either. Okay, so vicarious liability is where that comes into play. So the company, the supervisor, the manager, we all have vicarious liability, even though we may have typical sometimes we're employees as well, but typically we're also responsible for our employees. So we need to make sure that they're following the rules. So we're liable, and we have liability in that regards. And then the facility actually has liability as well. So typically these are kind of some things that we would work on to understand, to minimize those risks. These are premise related issues. Typically we need to make sure that everything's up to standard. There's an ability to inspect. Everything is up to snuff and it's up to industry standards. And then we have the ability, need to have, anybody has the right to see those types of things. You see the notices in the elevators and those types of things. That's the type of thing that we would be talking about here with the aspect of inspection. And then supervision, we look at general supervision, how that is handled in regards to liability. So we have general, specific, and transitional. Okay, general is just kind of the fact that, okay, the facility or the company, subcontracted company employs you. That means that there is general liability and general supervision implied there. Specific and supervision is that specific. I manage this particular concession stand, or I manage this particular area, and I have 10 employees that are working there. That's specific supervision. Okay, and then transitional means that there is some flux in regards to the supervision that's there. And typically that would be the next level up. Oops, sorry about that. Premise related issues. That's why most public facilities now there is not ever a time when there is not certified EMTs that are involved. Typically, the city fire department and rescue department are on site in order to provide medical assistance. Okay. And typically, emergency care is all about the emergency, is about risk management planning. Okay, what to do when, and you turn that over to the EMTs or other personnel that would be there. And typically, a lot of cases, it's athletic trainers are there for the athletes, but they also would assist in any other case. But typically, in most public buildings now, you will have EMTs on site. You may also typically in most pro sports, you're also going to have doctors on site during the game, as well as athletic trainers. So a lot of those guys you see running out on a football field on Sunday, typically, usually one or two of them are doctors in addition to the athletic trainers. So the trainers will go out as well as the doctors, and typically the doctor will make the assessment depending on what, and usually there's more than one on the sidelines of a pro football game. Provisions of emergency care and the aspect of risk management planning comes into a huge play there. You need to know where things are. And then you have this last little bit here is on human resources. We all, just like any other business, we have to work against sexual harassment. And again, this now is disability, sexual orientation, any of those types of things. We have a responsibility to provide that. If not, we could be liable. And typically, we need to make sure that we are hiring training and supervision of employees. We have to neglect to design means that we're not doing one of these things in the correct way. So typically, you will find everything very specified out in regards to HR and how you would handle it. It is all covered in a handbook, and individuals really kind of play into we as managers need to manage that process. Apologize for being a little long. This one has got 3 chapters here, but hopefully you found this kind of interesting and informative. And I'll see you next week.